What are some of the moves that you've tried to access before? I know that you've mentioned about going to JSC, but does it mean that every other door when it comes to negotiation of just having a conversation around this with the judiciary have fallen on deaf ears? Because by the time lawyers are downing tools, what that means is that those who have a court date, say today, are not able to get justice, So what's the trade? Have you tried other maneuvers before that have not been adhered to, or what's the case?
That's a very good point. In fact, in our statement of Friday, we did recognize that lawyers are essential service providers. We are like doctors. We are among the people who during COVID were given leeway to travel from one place to the other. So when you're an essential service provider, it doesn't mean you cannot take industrial action. You've seen doctors going on strike, but it means they have to be limited or balanced, because you also need to think about the interests of the Kenyans you are serving. And that is why our general court boycott is for only 1 day. We could even have decided to do a full month. We said, let's do 1 day and see whether it will have an impact. Even sometimes we have public holidays that are very unexpected or unscheduled, like this National Tree Planting Day. And of course, we know there are some religious holidays that also are decided, they move with the calendar. And when that happens, the courts don't sit on that particular day. Cases get adjourned to another day. So we are saying a 1 day temporary inconvenience of litigants is important for the sake of the greater good. When people go to the streets marching or protesting, like LSK, we went to the streets 1.5 weeks ago, the traffic is inconvenienced. They have to slow down as you are walking along the road. But you even have police assistance. But Article 37 recognizes some measure of inconvenience for the public is okay, because it is part of exercising your freedom of assembly, your freedom of demonstration, petition, and picketing. You understand? So that is what LSK did. So we looked at the proportion. We said for 1 day, it's general court boycott. All courts, even for that 1 day, we've given a few limitations or exclusions, because there are people who have what we call interim orders. You have maybe an injunction or something, and it's coming to an end on that day. So you will need to attend court just to tell the court to extend the order and give you a new date. So we've actually considered those exceptions. It's like when you protest, there are still some people moving in the streets. You give them 1 lane on the side. They don't have the 3 lanes, but they have 1 lane to move in. So that's what we've done. Then we've also said we'll have an indefinite boycott of certain courts. We couldn't do an indefinite boycott of all courts. It would not even have made sense. But we identified a few judges and judicial officers who are enjoying court orders. They are currently sitting by virtue of court orders. So we've said for those specific courts, we are doing an indefinite boycott until such a time as those court orders are lifted, so that they can go through the accountability process.
The judges themselves?
Yes, exactly.
Judges and or magistrates?
Exactly. And what happens is that we started discussing this issue as far back as 2 years ago in the LSK annual conference of 2024. We discussed it again in 2025. We've discussed it in several forums. We've raised it in our meetings with the judiciary leadership. But we've noticed some judges or magistrates are personally enjoying these orders, so they don't feel any motivation to advance their cases. And the experience is that those are some of the cases that then drag on. They delay much longer than any ordinary case.